Start. The court considers it appropriate to highlight the fact that delays of 9-10 years or so on the part of the functionaries of the state arrayed as respondents is not an isolated matter in the present case. The need arising, this court would not hesitate in directing compilation of data in this regard. And this comes along with a barrage of criticism by the litigants about delays in the dispensation of justice, which includes the state litigants as well. There have been in the past of which judicial notice must be taken, directions to functionaries like the chief secretary and so on to streamline matters, but these are usually forgotten with the turn of the day. To the individual litigants, not by dozen or scores, but a far larger number, the story remains the same. The state's returns in their causes are awaited. In this case also, if the court had not directed the two official respondents to appear in person, void our order dated 3/11/2023, the return filed on 19/12/2023 would not have been put in, maybe for some more years. So much for the necessity and usefulness of enforcing personal attendance of parties and witnesses, without which no court can function. The reason for the delay in filing a return in this case is furnished by the DIOS in his personal affidavit dated 8/11/2023. In paragraph number 4 of the DIOS affidavit aforesaid, it is averred that the delay in filing the counter affidavit is due to the fact that since the record of the present case was misplaced in the office of the answering respondent, due to which it could not be noticed that the counter affidavit has to be filed in the present writ petition. It was after receiving the notice regarding the order dated 3/11/2023 passed by this honorable court in the present writ petition, the answering respondent get the record searched in his office and is filing the counter affidavit. However, the deponent tenders his unconditional and unqualified apology for the inconvenience caused to this honorable court by this act of the deponent. If for a misplaced record, the counter affidavit in a cause could be delayed by as much as 9 years and a half, the sense of responsibility of this protesting galaxy of official litigants who were protested every appearance in court can well be fathomed. We have already indicated the peril of proceeding ex parte if a respondent is not putting in his return in our order dated 3/11/2023, and there is just no way but to ensure that returns are filed by respondents, whether private or public functionaries. Ex parte judgments and then their relatively liberal recall by stabilized standards of procedure do more injustice to the litigants than any kind of justice to the cause. When this matter came up on 8/11/2023, the parties having exchanged affidavits, at least the respondent's return being there, the petition was admitted to hearing, which proceeded forthwith. The matter was adjourned on 8/11/2023 for further hearing to 30/11/2023. On 30/11/2023, there was no time and the cause had to be adjourned to 14/12/2023. In the meantime, on 13/12/2023, the petitioners filed a rejoinder affidavit in the office. The matter was finally heard on 14/12/2023 in the presence of the learned counsel for the petitioners and the learned counsel for the state, representing respondent numbers 1, 3, and 4. No one appeared on behalf of respondent number 5. Despite service being sufficient, there was no appearance on behalf of respondent number 6 as well, though the said respondent was adequately served in and service upon him was held sufficient on 14/12/2023, when the learned counsel for the appearing parties concluded their submissions. Judgment was reserved. Heard Mr. Om Narayan Dwivedi, advocate, holding brief of Mr. Nath Mishra, learned counsel for the petitioners, and Miss Monica Arya, learned additional chief standing counsel, on behalf of respondent numbers 1, 3, and 4. In the counter affidavit filed on behalf of respondent numbers 3 and 4 jointly, it is admitted that the late Vishan Singh was selected as the principal of the respondent college or headmaster, whatever be the designation by the selection board. It is also acknowledged that on receiving the panel of selected candidates, the DIOS, void his letter dated 15/1/2004, directed the Committee of Management of the respondent college to hand over charge of the principal to Vishan Singh. It is also admitted that in compliance with the DIOS direction, the respondent college, by a resolution of the Committee of Management dated 19/1/2004, resolved to hand over charge to Vishan Singh, which was handed over on 24/1/2004. It is next said in paragraph number 5 of the counter affidavit that the officiating principal Jaswant Giri filed a writ petition before this court, being writ petition number 4941 of 2004, where this court, void order dated 11/2/2004, stayed the operation of the order passed by the DIOS, which resulted in restoration of the previously working incumbent Jaswant Giri on the post of officiating principal. A perusal of the order dated 11/2/2004 passed by this court in writ petition number 4941 of 2004 shows that what was stayed was the operation of the order dated 19/11/2004 passed by the DIOS and the order dated 24/1/2004. Now there was no order dated 24/1/2004 as such. It was just that on the said date, Vishan Singh took over charge of the respondent college as the principal. It is next averred in the counter affidavit that Vishan Singh moved special leave petition number 7125 of 2004 before the Supreme Court, wherein void order dated 7/4/2004, while issuing notice on the SLP status quo in the meanwhile was ordered. The SLP was tagged by the Supreme Court with other special leave petitions. It is admitted that by judgment and order dated 16/5/2008, the interim order passed by this court dated 11/2/2004 was set aside. It is also acknowledged that in compliance of the aforesaid judgment passed by the Supreme Court, Vishan Singh was restored to his position as principal of the respondent college with effect from 4/7/2008. He occupied on the position until his retirement on 36/2009. Over.